freedom of speech,
fundamental rights,
freedom of conscience,
academic freedom,
freedom of press,
and the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Welcome back to So to Speak, the free speech podcast, where every other week, you and I take an uncensored look at the world of free expression through personal stories and candid conversations. I am your host, Nico Perino, and during today's conversation, I speak with Institute for Justice President and General Counsel Scott Bullock. As some of you may recall from my conversation in April with IJ attorney Sam Gedge about campaign finance laws, the Institute for Justice is a nonprofit, libertarian, civil liberties public interest law firm that litigates within what it calls its four pillars. Those pillars represent economic liberty, private property, school choice, and the focus of our conversation today, free speech. The Institute's litigation in the free speech space is quite unique. Their cases aren't your typical First Amendment cases when you think protest bans, controversial speakers, or censorship of political dissent. Scott told me in this conversation that other organizations, including FIRE, do a great job on those fronts, and that rather IJ likes to litigate in the spaces of commercial speech, occupational speech, campaign finance, and sign codes, cases that are typically ascribed to the margins of First Amendment concerns by the public and judges, though I should say IJ is doing its best to reverse those trends and finding actually some remarkable success, and we'll talk about some of that success today. I met with Scott at IJ's Arlington, Virginia headquarters on Monday, November 27th, because I wanted to learn more about the origins of the Institute's unique and in some cases controversial brand of First Amendment litigation. Of IJ's current staff, Scott is actually perhaps best positioned to explain that origin story. He joined the Institute at its founding in 1991 and was involved in all of its early First Amendment litigation in the 1990s. We discuss those early cases on this episode and explore the formation of IJ's litigation strategy before we dive into some of IJ's more recent cases and discuss some of the criticisms of IJ's First Amendment litigation strategy. Two quick programming notes before we begin this episode. Full disclosure, I worked at the Institute for Justice for about a year or so, from 2014 to 2015. Also, at the end of the podcast, I asked Scott Bullock about arguing in front of the Supreme Court, and I erroneously note that he is our first guest who has argued in front of that court. That is not true. And it's not only not true, it's really, really, really not true. Those who have appeared on the podcast or been featured guests on the podcast who have argued in front of the Supreme Court include Bob Corn Revere, Martin Garbus, David Cole, Floyd Abrams, Kathleen Sullivan, and perhaps one or two other guests that I'm missing. We can now, of course, add to that list Scott. He argued the 2005 eminent domain case, Kelo v. City of New London, before the court. And anyway, I apologize for that brief brain fart, and we will get onto the show now. Here's Institute for Justice President and General Counsel Scott Bullock. By way of introducing this, I want to reflect back on when I was a staffer here in the communications department at the Institute for Justice, and my first impressions of the Institute's litigation was that it was different from maybe the way FIRE litigates or the way the ACLU litigates, insofar as it wasn't seeking to maintain the status quo of First Amendment jurisprudence. It seeked to expand it in certain ways. Was that always the intention of the Institute's First Amendment litigation, or did it develop organically?
Well, our intent is always to seek precedent-setting cases, to really establish precedents that protect not only our clients, but people in similar settings as well. So we always very carefully select the clients we represent, the issues that we take on. And as you know from being here, IJ specializes in 4 areas: economic liberty.
The 4 pillars.
That's right. The 4 pillars: economic liberty, school choice, private property rights, and free speech. And free speech has been a part of our work really since the beginning. And what we really sought to do in our free speech work is to recognize vital constitutional liberties that were being underprotected by courts. And so that was always at the heart of our free speech work. And as I said, it's really been a part of IJ since our founding.
Yeah, speaking of the founding, Chip Miller is the former president of the Institute for Justice, and his co-founder, Clint Bullock, when they were announcing the formation of the Institute for Justice in September of 1991 at the Heritage Foundation, they gave a speech called The Quest for Justice, Natural Rights and the Future of Public Interest Law. And I reread that speech just prior to this interview, and the First Amendment's mentioned twice, and the more substantive place where it's mentioned, Chip said, "When we sue for a uniform First Amendment standard for all media, regardless of the technology involved, we will seek the unfettered flow of information that people need to exercise political freedom and to participate in a thriving market economy." He mentioned their, technology. He mentioned political freedom. And economic freedom, thriving market economy. So was the First Amendment litigation that you sought to do always viewed from that umbrella? The internet, new technologies, political speech, and economic speech?
Absolutely, and it was there since the founding. Chip and Clint had that as the vision when they had founded IJ, and one of the things that IJ has always sought to do was to remove sort of these false distinctions as we see it in the Constitution, where certain rights are given close constitutional protection and strict constitutional protection, and other rights, even though they should be protected by the Constitution and are vitally important, are basically given second-class status under the Constitution. And that's true for private property rights, true for the right to earn an honest living, which is what our work on economic liberty is all about. And it's true for certain types of free speech as well, where certain types of political speech are not given robust constitutional protection, especially if it's in certain contexts. And commercial information as well has, for the past several decades, even though thankfully it's getting a little bit better now, commercial speech has been given lesser protection under the First Amendment as well, even though the First Amendment itself doesn't make any distinctions between these types of speeches.
And your first involvement in First Amendment litigation was at the amicus stage, and you were telling me it was in front of a case in front of the Supreme Court dealing with sidewalk solicitors, more or less.
Yeah, it was basically newsstands, and it came out of the city of Cincinnati in a case called Discovery Network, which kind of went to this very issue where the city of Cincinnati said, well, we don't want a lot of clutter on our streets, so they just came up with the solution that only certain news organizations have the right to put their publications and handbills and other types of speech on the streets. If it's just commercial information, then we're going to ban that from city sidewalks. And it was, again, this kind of false dichotomy of saying certain types of speech we value, other types of speech we don't value, even though some of the publications that they were banning, for instance, were publications about buying your home, which is one of the most important economic decisions, certainly, that a person or a family can make.
Or presumably your new business down the street, which if it doesn't get off on the right footing, you might fold, and then you can't pay for that home.
Then you can't pay for the home. Exactly right. So, it really went to one of the points that we were trying to make, which is all speech is worthy of protection, and government should just not be able to make up these categories and say, we're going to protect some and not others, and if you happen to fall into a category like commercial speech, you're out of luck. So we filed a brief in that case and made the point that, for instance, for the average person, finding out information about a home is more important to them personally than finding out, for instance, what's happening in Bosnia was the example that we used at the time, because, of course, that That was at the time in the early 90s when the Bosnian war was going on. Not to say that finding out about what's happening in the world events isn't important, but other types of speech is also very important, and people ought to have access to that. That's actually that very point was made by Justice Scalia in the argument as
Hopefully
well.
After
so that
reading your brief,
exactly. Hopefully, after reading that, and Tony Morrow of the Legal Times actually pointed that out and saying, well, this is actually a point that was made in the Institute for Justice's brief as well. So of course that was great in the early days of IJ to get that sort of recognition. But as I said, it really went to this fundamental point that we were trying to get through about the First Amendment. And thankfully, in that case, the court struck down this prohibition and started this trend toward recognizing greater protection for commercial speech, which is something then we eventually maximized in our own cases as we started to take those on later on in the 90s.
Yeah, and your first case was in 1997. It dealt with an attempt by the Commodity Futures Trading Commission to license internet and software publishers who published information about commodity trading. The impetus for that case, it was your first one. What made you decide to take that as where you were going to plant your First Amendment flag?
Well, it again really captured a lot of what we were fighting for in free speech, and kind of the reaction that governments have oftentimes to emerging technologies. And that was something you had mentioned in the speech that Chip had made about the founding of IJ, where we were going to make sure that as technology developed, that free speech and other constitutional rights were protected in that context. And this was a kind of a classic example of government overreaction to something that we and a lot of other people saw as a great thing, which was the development of new technologies, the ability to share information directly with people in a fast and efficient way. The government saw as a real threat. And that's what happened with the CFTC.
Well, I remember there was a lot of scaremongering happening in the 90s surrounding these emerging technologies. There was that Time magazine cover where it had this scary picture of a person looking at a computer screen, and it had something to do with child pornography. Do you remember this?
Yeah, of course. And that's why the Communications Decency Act and all these attempts to say, oh my God, people might have access to information. We've got to get a handle on this. We have to control this. This is a danger. This is a threat. And you saw that in what Congress did with the Communications Decency Act, which was eventually declared unconstitutional.
Was there any interest in chiming into that conversation on the Institute's part?
We saw that, and we kind of kept an eye on it. But
the ACLU was doing a lot of
exactly, and one of the things we don't do is kind of me too the work of other organizations. We think the other groups are doing a good job of doing that. Like FIRE does a phenomenal job supporting free speech on campus. The ACLU, when it focuses on civil liberties,
flag burning,
flag burning, and sort of these types of unpopular speech, and they also took on the Communications Decency Act. So we didn't see the need for doing that. But there were other attempts by government to regulate the internet, like what this federal agency, the Commodity Futures Trading Commission, was doing, where they saw this as a problem because now people who were basically giving advice about commodity trading, who used to have to do this in the form of a newsletter that got to people usually several weeks after the information sometimes was relevant, were able to communicate directly with people or to offer software that would tell you, here's where I think you ought to buy the gold contract when it reaches this target price. And the CFTC thought, my God, people are going to get this information and they're going to get it instantaneously because of the internet and email, and this is a terrible thing, so we've got to regulate it. So they came up with this idea that they said anybody who offers their opinion about commodity trading has to be licensed as if they were actually taking your money and trading it in the marketplace. And so these people aren't trading commodities. They're just saying this is where I think the market's going to go. They're offering their opinion.
They didn't license these newsletters prior to their going on the internet, did they?
Well,
or did they try?
They tried to it back. This SEC actually tried to do this back in the 80s and was told, and it wasn't a constitutional decision. They said that they didn't really have the statutory authority to do this, although a lot of agencies still thought they had the ability to do this. But when it got online, and when this was actually could be useful information, they said, now we got to get serious about this, and we're going to license these people and make sure that not anybody could just offer their opinion about commodity trade.
Did they go after, for example, people on cable news? I don't know if CNBC was around at that time, or the Wall Street Journal columnists who give commodity advice.
Well, they wrote into the law what they called a media exemption. So if you were if your publication did not deal primarily with commodity trading, then you were exempt from the licensing requirement, which of course doesn't make sense, because as we pointed out in the case, and actually a trial that we had about the case, that the Wall Street Journal and Forbes has opinion columnists in there that give the same type of advice about what they think is going to happen in particular commodity markets for it. So they were exempt, and the impact was felt greatest upon these small software publishers and newsletter publishers as well. And it really goes to the heart of something that the founders really wanted to avoid, which was the licensing of the press. This was something that the king had tried to do in England, and then of course
John Milton wrote about it.
That's right. This is one of the fundamental points of the First Amendment, is that you can't license the press, because if you do that, then only the people that are favorable to the government get the licenses for it. So they warned against licensing the press. And here, 200 years later, this federal agency is trying to do this in response to what they saw as the real threat of emerging technology. So we thought it was a great case, captured a lot of these issues, and we took on the case, sued the CFTC on behalf of a lot of these small publishers, and it actually went to trial in district court in D.C., and it was the first case at that time that had live internet access for it. The courtrooms at the time in the late 90s, the trial was in 1999, and courtrooms were just then starting to be wired for the internet. And actually, it was the same. Our case was happening at the same time. The Microsoft antitrust trial was happening right down the hall. So all this was happening in the context of it. What was interesting
is the most 90s story ever.
Totally 90s, very, very 90s. But the Microsoft courtroom hadn't been wired yet. So here they're dealing with this, this big issue.
Well, what were they wiring it for? What were they doing with the internet?
They were able to. I mean, you could then actually pull up things. So you had computer terminals. The judge had internet access. The parties had internet access. And now, of course, this is how all courtrooms operate. Actually, now courts are basically getting away from paper filings. You basically don't file actual papers with most courts now. You just upload things online in the form of a PDF. The court gets it instantaneously. The other side gets it instantaneously.
You get an electronic stamp.
That's right. And here, they were just starting to do this. And so we were able, and I think the judge wanted to figure out what's really going on here. And so during the course of the trial, we were able to pull up the websites, and he said, yeah, this is just information. People can do with it what they want. They can accept it, reject it, modify it, but this is just people offering their opinions about it. If you like it, you keep subscribing. If you don't listen to what the person's doing. So, but it was a trial where all of us were online and for the first time, and we got this great decision from the district court reinforcing this principle, saying that you can't license the press, and the press also includes small publishers like this, online publishers like websites themselves, software developers, and it set an early precedent that guaranteed free speech rights in that context and said government can't license this. If it would have gone the other way, then this would have set a very dangerous precedent where government would have been able to come in to say, well, only certain people are able to offer their opinions online or in software.
Did the government appeal it? Or was
They originally appealed it, and they were going to go up before the D.C. Circuit, and then somehow cooler heads prevailed, or maybe they saw the writing on the wall in the way that courts were going on regulation of online content, and they eventually dropped the appeal, changed the regulations so that people were allowed to offer their opinions. If you take people's money and trade it in the market, of course you have to be licensed, but not when you're just offering advice.
So a big first win for you in IJ's First Amendment case.
Yeah, it was a really big win for us.
Did you know anything about First Amendment litigation prior to this, or was this
Well, we were
a learning process?
Yeah,
for you?
we were starting to plant our flag in this mainly through the filing of amicus briefs, like in Discovery Network. This was actually IJ's first trial that we ever did as well. I mean, we typically tend not to do trials because our cases are relatively simple. The facts are simple, and we're arguing about the constitutionality of laws. But we've actually had a lot of trials since that time, so it was a great learning experience for us to when it comes to actually litigating a case and how we did that. And it, as I said, it set this important protection for internet publishers and software developers in the early days of the internet. So it was a great case, and it actually then opened up a whole new avenue for our First Amendment we've been developing since that time is in this area of occupational speech, where free speech rights basically are coming together with our economic liberty work, and we're trying to defend the ability of people to basically speak for a living. And as you know, we've taken on a whole series of cases that go to that.
Yeah, let's talk about some of those. So your most recent one deals, I have it here on my notes as the horseshoe lawsuit.
Yeah, that's a good description of it.
Where it's more or less this man. Are there two plaintiffs in the case?
Yeah, well, there's the school, and then we have some students that want to go to the school.
Yeah, and the school, you can explain it better than I can. So
yeah,
I'll let you.
Well, it's all it's not just that case, but it's a whole range of cases that we've taken on, a whole series of them, because what you see now, especially with the rise of new technologies, but also even in more traditional fields like with the farriers too, that increasingly occupations are about speech, and that people are talking for a living. And that's true of a lot of online content, and it's true for a lot of even teaching type of professions. And there's this clash in the law where by, again, certain types of speech are protected, but then governments say, well, you're dealing with an occupation here, so we can basically regulate this and license it as we see fit. And if the occupation is fundamentally about speaking, free speech should apply to that. And that was our point we made in the early CFTC case that we just discussed. These people are not trading commodities, they're just talking about it. Therefore, free speech ought to apply. And it also should apply to people like the fellow in California that's just offering to train people on how to shoe horses, and is being told, well, in order to accept students into your school, they have to pass a government-mandated exam. They basically have to have a high school diploma or a GED or a government-imposed equivalency for it before you are allowed to accept them into your school. And I said, well, listen, these people just want to learn about shoeing horses. They have a right to do this. People are willing to pay somebody to teach them this. The person wants to teach them this. It's none of the government's business to do it. They're exercising their free speech rights. So we sued on their behalf. Of course, this also impacts people, low-skilled people, oftentimes people that don't have a formal education. It's a great way to be able to earn a living and are being kept out of the marketplace. Another example that we have of a more recent case that really captures this issue so well is the woman in Florida who's offering speech about basically healthy living. She's a health coach, And a lot of people are into this now. They talk about
this case sounds familiar.
Yeah,
it's similar to the caveman blogger.
Exactly
case,
right. It's building upon the caveman blogger case, which we did, where somebody was offering their paleo advice online and was told by the state board that well, you can only say it in this way for it. He said, well, listen, I just want to offer my opinions about. You needed
like a dietitian license.
A dietitian license. Same thing is happening in Florida, where a woman is a health coach, certified privately as a health coach, and she's talking to people about diet and exercise and giving advice to people and kind of coaching them as to how to live a better and healthier life. She was, ironically enough, doing this in California without any problem whatsoever. Her husband's in the military. He's transferred to Florida, and she starts doing the same thing in Florida, and she's turned in. Was she turned in by, of course, a disgruntled member of the public? Absolutely not.
Her competitors. She
was turned in by a licensed dietitian who was saying that, well, you have to be licensed by the Department of Health to do this. The Department of Health ended up doing a sting operation on her to find out what she was doing, where an investigator actually contacted her posing as a potential client and doing this, and then was issued a cease and desist letter saying that you're not a licensed dietitian. In order to become a dietitian in Florida, you have to have a degree in health or dietetics. You have to apprentice for a significant period of time under a licensed dietitian. You have to pass an exam, pay fees, all of this. And of course, all she's doing is offering her opinion. She's not claiming she's a licensed dietitian. There's no claim of
money
fraud
changing
or anything
hands?
like that. They are paying her for it. I mean, they are paying. That's
that wasn't happening in the caveman blogger.
That's right. Well, with the part of the caveman case, they actually were. He was offering his own opinion about it, and you could pay it, though, for more personalized advice for it. So, and they were upset about that as well. So people are offering her compensation, but again, it's just to, here's how I think you could eat healthier. Here's an exercise routine that might work for you. And it's basically just kind of encouraging people, checking in with people, and some people need that nudge in order to stay on target for these things. But what's interesting about this too is that she is just offering her opinion, and it goes to, as I said, this a combination of this assault we see upon people that are trying to earn an honest living through and are being faced with occupational licensure. But it's even one step beyond that, because here she's actually just speaking. It's pure speech, and the government's still saying you need to have a license to do it.
What would you say to people who say, well, Scott, you're a lawyer and all you're doing is just speaking?
Yeah. Well, I mean, it's interesting because I actually think that there are certain instances where the government is regulating the legal profession in a way that impacts free speech rights, because sometimes lawyers are and actually there's been some legal software, for instance, that's gotten in trouble.
Like LegalZoom or something?
Yeah, exactly, by certain state bars that have said, well, you're engaged in the unauthorized practice of law. And what you're oftentimes seeing is that one of the great things about technology is that it allows you to do for yourself what you once had to hire a professional to do for you. And this is clashing with these licensing regimes that say, well, you have to be licensed by us and you have to meet certain qualifications, even though for the most part what these people are doing is they're actually doing it on their own, just with the help of technology. Lawyers are a little bit different, because oftentimes what lawyers are doing, you're acting as a representative of somebody, you're acting as a fiduciary to somebody, you're forming a relationship with them, and then that makes for a stronger argument for licensing and regulation. But in the case, for instance, of like the caveman blogger or the woman who's offering diet advice in Florida, she's just offering her opinion. People can do with it as they wish. She's not in any way kind of taking their affairs under her own hand and representing
in the same way maybe a medical professional, like your doctor would be. Would you say if I'm going to my doctor and I have a cold or the flu or what I think is a cold or a flu, and I go for advice as to what that is, would you say that should come under the protection of the First Amendment as well, up until the point, presumably, where they start prescribing medicine?
Yeah, I mean, and this is what we're actually arguing in a lot of these cases, is that courts should look at this to see what the justifications are for it, rather than what governments want courts to do, which is to basically say, oh, this is about an occupation, then there's no free speech protection for this whatsoever. We can regulate this just as if we're regulating a doctor or a lawyer or somebody who's really kind of exercising judgment on people that might be a life and death matter, where there's financial responsibility like a lawyer might be doing in representing you. There should not just be this rubber stamp. There should be actual scrutiny where the government has to prove, like, well, hey, here we're talking about people's health and well-being, and there should be some real basis for a licensing requirement in those instances. But if it's just about speech, like a blogger or like the woman who's giving diet advice, then free speech should apply, and the person should not be required to get a license.
And you've had some success in this space as well. I recall my IJ days when we were doing the tour guide cases, and you're still doing the tour guide cases. And we had this great SACO, which IJ's jargon for talking point, strategic overriding communications objective.
You remembered
yes,
it, Nick.
I do.
All right,
and
good deal.
The talking point was tour guides just tell stories, and in America you shouldn't need a license to tell a story. And where have these licensure programs been struck down? Savannah?
That's right. Yeah, we have a couple cases that are pending right now. We're actually going to trial in our challenger in Charleston, South Carolina. That's right. Philadelphia repealed theirs once we filed a lawsuit against it. Washington, D.C., we got Bob McNamara and the team here got that law struck down.
Big win at the circuit court.
Big win at the circuit court. Unfortunately, the Fifth Circuit in New Orleans went in the opposite direction, upheld the law there. So, at a certain point, the Supreme Court might step in. But yeah, it's another classic example of where the government is trying to license what really is just speech, in the same way that a stand-up comedian might be offering jokes. A tour guide is just telling you stories about the history of the city. There's all kinds of ghost stories which are clearly not true, but at least some people are interested in it. There's some history behind that as well, and you just ought to be free to offer your opinions on this, and you should not be required to get a license in order to just exercise your speech.
You mentioned that you want courts, when they're looking at these cases, to take more or less a fact-intensive approach to analyzing whether these regulations are necessary. They more or less need to be narrowly tailored to serve a significant government interest, and they can't overburden speech. Are you trying to take a First Amendment backdoor to get after these economic liberty cases that you pursue in your other pillar? To set the scene, and you can probably explain it better than I could, in these economic liberty cases, the government needs a rational basis by which to regulate your economic activity. But when we're analyzing speech, the courts take what's either intermediate or strict scrutiny in analyzing whether the regulations of speech pass constitutional muster. And in those cases, it's much higher bar for the government to reach. So if you can somehow place the mantle of the First Amendment on your occupation, it becomes much harder, therefore, for the government to regulate it. And we're seeing this in other places. Like right now, and it's probably going to be unsuccessful, there's this car dealer who's raising First Amendment defenses in his firing of a transgender person. It seems like everyone wants to take upon them the First Amendment because it's easier to win.
Yeah. We are not trying to do that. Actually, because we are trying to, as from our work on economic liberty, we are trying to raise the level of scrutiny that governments give economic regulations to mean that the rational basis test actually means something. It doesn't mean that the government always wins, that the courts just rubber stamp whatever the government wants to do when it comes to to regulating and licensing an occupation. So we're trying in those instances where it actually involves, for instance, hair braiding or taxi cab licensing or casket retailing and a lot of these other professions that we're doing, is that the government has to actually meet the rational basis test, and they actually have to have a real justification for what they're doing, as opposed to what it normally is in these instances, which is pure economic protectionism. But if the occupation actually does involve speech, then we do argue free speech rights and say, and just if it's speech about an occupation, you just can't simply say, well, we get to have carte blanche to do what we want. You actually have to give real scrutiny to this because free speech rights are implicated. In other instances, free speech rights we recognize are not implicated or not implicated to a great degree, but still the justifications for the licensing law can't be based upon economic protectionism. That's been our focus in those cases. And in the free speech cases, we're arguing for a robust protection for free speech, even in the occupational context.
Why would you say then those people who are wrong, who argue that when the founders conceived of the First Amendment, they conceived of it in the political sense? You see some of this on the Supreme Court. I think Breyer is a proponent of this. He says, speech deserves higher protection only insofar as it furthers a democratic interest. How does IJ push back on that? I mean, what founding documents are you looking at to justify that the founders actually meant it when they said make no law?
Yeah, well, I mean, a part of it, and what you can really go to, is just the text itself, which you should always start with, as opposed to just, kind of people's thoughts about this. I mean, the text itself is very strong. It says Congress shall make no law, and that should be taken very seriously, and it should only be in really extreme circumstances, like when speech is really just a part of an overall conduct, like inciting people to violence or to rioting or that sort of thing with it. But even the earliest newspapers, for instance, in the Republic, had commercial advertising attached to it. Commercial speech was bound up with political speech with it. The founders were not making—
You had to pay to get the newspapers.
Yeah, these sorts of distinctions at all. And you see this all the time through these false dichotomies. When you say "Buy American," is that political speech or commercial speech? Environmentally friendly products. Is that commercial speech or political speech? Of course, it's both. It's a little bit of each. You're making a statement about your support for certain ideas in some ways, but you're also doing it, of course, to get people to buy the product that you're selling as well. And I think the founders recognized that you said you have to buy the newspaper. Newspapers need a way to support themselves with it, and so this speech was all speech should be equally protected. And if you look at the text of the First Amendment, it's pretty clear that the government should meet a very high burden before it really prohibits any sort of speech, and whatever medium that speech might be delivered in then too.
But IJ has done its fair share in trying to expand protections for First Amendment speech that deals with political speech. First Amendment speech, that's a bit redundant.
Yeah, that's right.
For political speech.
Yeah.
And have entered a bit of a controversial area in trying to push back against some campaign finance laws.
That's right.
Most notably your partnership with
Center for Competitive Politics.
But they just recently changed their name.
Yes, that's right. That's right. Yeah, that's right. Yeah.
But in the Speech Now v. FEC case.
Yes.
So tell us a little bit about that.
Sure. Well, it goes back to kind of our founding as well.
Yeah, it looks like your first campaign finance case wasn't until '99 in the Arizona Clean Elections Act.
That's right. And so what we were doing there, and it's really since our founding is to also protect political speech as well. That's an equal part of the First Amendment. It's certainly entitled to robust free speech protections, and so we were always interested in doing that, and we're always strong supporters of the right of folks to share political information in addition to commercial information and other types of speech as well. And what we were mainly doing there, we didn't have a big interest in representing politicians or political parties. They have large phalanxes of lawyers that can kind of take care of themselves. But what we oftentimes saw are in instances where campaign finance laws, which really do impact a lot of free speech rights. And again, there was sort of this trend when campaign finance laws were being talked about and introduced that they should not be given clear and strict First Amendment scrutiny. They should be kind of just treated as if you were regulating the kind of general economic regulation. We thought that was incredibly misguided. And what we oftentimes saw was campaign finance laws impacting grassroots activists and people that were on the ground organizing about politics, talking about politics, and they were being met with campaign finance regulations, which are oftentimes really difficult to understand and are very burdensome as well. Again, political figures, political parties, it's kind of a cost of doing business. They hire a bunch of lawyers. They kind of walk them through the regulatory maze. But for instance, we started representing people that were speaking out against ballot initiatives. We had a great case in Parker North in Colorado where it's kind of a classic local issue about whether a certain area of town should be annexed to be a part of the city. And citizens were talking about, some were in favor of it, others were against it. And what these folks were facing is that they were being treated as if they were actually large political action committees or political parties where they had to register with the Secretary of State, file financial disclosure documents, have a treasurer, do all these things that are very difficult to understand as to whether you're even
all in order to advocate for or against an annexation.
Exactly right. In order to speak your mind, you had to do this, and of course, it had a direct impact on their ability to do it. Oftentimes, these laws, as we saw, and we're still seeing this today, are used by political opponents to silence it. They file complaints against the other side, saying you're violating the campaign finance laws, and then the people are kind of totally distracted with trying to fight off this investigation rather than speaking about the issue of the day. So we started taking on a whole series of cases that went to this application of campaign finance laws, these oftentimes Byzantine, very complex, very burdensome campaign finance laws, to grassroots kind of citizen activists and highlighting the impact that it had on their ability to speak.
So Speech Now came in the aftermath of Citizens United. Citizens United said that corporations, include trade unions and nonprofits, can use general treasury funds to make independent expenditures, supporting this or that candidate or this or that political issue. And independent expenditures mean they're not coordinated with any candidate. So you seized on that and then decided, well, if corporations can do this, why can't you and I joining together do the same thing to spend unlimited amounts of money advocating for or against our favored political candidate or disfavored political candidate? And why do we have to have a cap and they don't? And also, why do we have to form a political action committee to do so? So you won on one of the issues and lost on the other issues, creating this so-called super PAC.
That's right. Yeah.
Which I understand isn't what you wanted them to be called either.
Right. Yeah. I mean, it's not a great name for it, but it led to this kind of change in the political environment that you see today. The main issue that we were litigating about, can individuals come together to spend money to advocate about politics? We won. And that was a case, you're absolutely right, that attorneys here, Paul Sherman, Steve Simpson, who was at IJ at the time, and a whole team of folks worked on and got this really important case. And, Citizens United is the one that gets all the attention. But actually, Citizens United did not have as much of a direct impact as Speech Now did because, for instance, a lot of corporations don't want to spend money on politics because they're going to piss off 50% of their customer base with it, given the political divisions that we see in America now. So the real people that want to speak about this are oftentimes folks, individuals that have strong opinions, want to unite and spend their money on political speech as well. And that's what Speech Now was about. It allowed folks to pool their resources to talk about politics, and it led to the creation of what a lot of people now call super PACs. groups, and
which I think
and a
Paul Sherman
fundamental
told me
change.
wanted to be called Speech Now groups.
That's right. Yeah, that would be a better just speech groups for it. So it was a case that was a follow up, and it was kind of a direct result of the court's reasoning in Citizens United. But it had a real impact upon people's ability to spend money on causes that they believe in, and it's led to a lot of very robust debate about politics and an inability, much to the frustration, quite frankly, of large political institutions, including political parties, that kind of want to control the debate, might have their favored candidates that they want put into power, but now people outside of that kind of system have the ability to spend money to try to convince people about their views, and it's had a real impact, of course, on the political system.
You've taken a bit of criticism for the Institute's position on disclosure, and that's the issue you lost, I think, in the Speech Now case, because I believe it was the Institute's position that individuals joining together to talk about politics and spend money on politics shouldn't have to form one of these pacts that you've already described as being pretty burdensome. But the court, and this we're talking about the D.C. Circuit, this was never appealed to the Supreme Court because I'm assuming they knew what was going to happen when they got there, seeing Citizens United. They said, no disclosure, the government has an interest in knowing who's spending the money, therefore you are required to abide by these PAC requirements. Why is the reasoning there wrong?
Well, in disclosure, it depends, because the law is a little bit in flux about this, and we've actually won some cases where they've applied these disclosure requirements, oftentimes to smaller political bodies, and to ones that are basically these grassroots campaigns for it. So that's where the law has actually been more protective of people's ability to speak anonymously if they want. And that's what we're really trying to vindicate in those instances, where especially where people are talking simply about issues and are advocating for instance, ballot initiatives and the like, that they ought to be able, if they choose, to be able to do that anonymously and not have to disclose this to the government, and to have it for the government to do with it as it wishes. And this was a part of free speech rights really since the time of the founding, going back to the Federalist Papers, which were published anonymously as well, and people they did not have a name attached to it. I think this does have its greatest impact upon, as I said, people who are at the grassroots level, and you see this sometimes
we've seen a bit of this in California, where people give to, what was it, I forget what the ballot initiative was there, it dealt with gay marriage. Someone donated to an organization opposed to the ballot initiative, and they lost their jobs.
Well, that's
because
right.
It was disclosed. That's
right. And so this is still in play, and you see this on all sides. There could be consequences for speaking out and giving money to certain ballot initiatives and having everybody know about that. Wonder if you're a public school teacher and you're in favor of school choice, and then all of a sudden your name is released as giving money to support a school choice initiative, or for instance you live in a very conservative place and you happen to support a gay rights initiative, and then all of a sudden your name is disclosed because you gave money to this. And so I think that courts, what courts have rejected in this area are sort of broad-based challenges to disclosure requirements. But I think what you're going to see in the future are the very cases that you're talking about. If there are instances where there's retaliation for people that are supporting or opposing certain initiatives, then courts are going to give greater scrutiny to that, and have at least left the door open to these sort of as-applied challenges to these ballot initiative disclosure requirements.
My final campaign finance question before I move on to my final question.
I was going to say your listeners are probably thankful.
I recently listened to a More Perfect podcast. It's produced by Radiolab, and they did a episode about Citizens United. And throughout the entirety of the episode, Jad Abumrad, who's the host, seems to take for granted that everyone is against money in politics. But my experience working in the world of campaign finance litigation is that those who are opposed to stringent campaign finance regulations don't necessarily think that money in politics is a bad thing so long as it's not the quid pro quo kind. And he didn't have anyone on the podcast who pushed back on that. He also seemed to presume that the more money you spend on politics, the more likely it is you're going to get elected. And that may be true, but we've seen recent examples, Eric Cantor, Hillary Clinton, Jeb Bush, spending gobs of money and not getting the seat that they are running for. And they seem to forget that there is something that stands between the money and the office, and that's the voter. When I was here at IJ on Halloween, John Kramer, vice president of communications here, came up with this great idea to compare how much money Americans spend on an election to how much money they spend on Halloween candy every year.
Yeah.
So do you think, I'll put it squarely, do you think money in politics is a bad thing?
No. I mean, because and you're absolutely right that it's really the voter stands in between this, and people can't force you to vote a certain way. All they're doing is exposing you to that information, and then it's up to you to decide what you're going to do with that information. And I think what a lot of people who object so vociferously to this ignore oftentimes is that having people ability to spend money on politics oftentimes increases the likelihood of getting unorthodox opinions into the political debate. Because, again, if it was all kind of determined by the big candidates, the political parties, people were not basically allowed to go outside of that system, then a lot of times these unorthodox opinions are ignored. One of the best, I think, historical examples of that
Vietnam War
was what happened with Eugene McCarthy, who was the candidate, who was a very progressive candidate in 1968, who throughout his entire life remained an ardent opponent of most campaign finance laws because his entire campaign was financed essentially by about 3 people on Wall Street who were very opposed to the Vietnam War. Of course, the establishment of Hubert Humphrey was the successor to Lyndon Johnson. They were in favor of it. They did not want. They basically wanted to have a lock on this issue, and they said, "We're going to give you this money. We want you to speak about this." Nobody thought he was being bought and sold by Wall Street at this point. They knew why everybody knew why he was doing this, but it allowed him to then launch a very significant challenge that almost toppled the hand-picked candidate of the Democratic Party at that time about this issue. And if it was not for the ability of those folks to step in to finance this, he probably never would have had a chance for it. So I think the ability of folks to be able to speak freely about this, to be able to spend resources on this, would actually lead to more unorthodox, more kind of anti-establishment voices being heard in the mix, and then ultimately it's up to the voter to decide.
Well, what about when someone already has the office and they're thinking about that big NRA check that they're going to get at their next election if they vote, in favor of more lenient gun laws? I mean, what's the argument for the money in politics there?
Well,
So let's say you're in office and you know that if you vote one way, you can't count on that check to your campaign, and if you vote the other way, you can.
Well, I mean, that's politics. So, I mean, that's something where you have to then decide. You could say then that all that, just if people were giving money to certain candidates based upon the votes that they take, then you don't know what's really motivating somebody. Are they doing this because they believe in Second Amendment rights? Are they doing this in order to get money from the NRA? You can't know what people's in their heart of hearts. All you can do is to allow other folks to challenge that person and to have the finances to do that. I mean, one of the other things too that's oftentimes ignored is the advantages of incumbency too, and the fact that an incumbent has all of these resources at their disposal in order to get out the word about what they're doing in office makes it all the more important for people who are challenging the incumbent to have the resources to overcome those advantages of incumbency in order to try to shake up the system a little bit.
Final question for you, Scott. You're, I think, my first guest who has ever argued in front of the Supreme Court. You did it in Kelo v. City of New London, the eminent domain case. What's the most surprising thing about preparing to argue in front of the Supreme Court or arguing in front of the Supreme Court?
Well, I mean, there's what we try to do, and what we certainly did in that case, is that we try to have that there's no surprises. You prepare so much in order to be able to anticipate and respond to any of the questions. And thankfully, we were able to do that in the Kelo case. We do that for all of our cases. We are really set on making sure our attorneys are the most prepared when they get before the court. One of the things that was most surprising to me when I got up there is how close you are to the justices. You can really see them. You really
smell if they brush their teeth.
I mean, they're seated. You're standing. So, and they're not that high. It's the high court, but they're not that high up. So you're all basically looking at them almost eyeball to eyeball with it, and you're not really that far away. And so that's the thing that's a little bit jarring when you first go up there. And then, of course, people who follow the court, know this, but oftentimes people think that the justice sort of lets you go on and listen to your impassioned oratory about something. And it's like facing kind of a semicircular firing squad when you're up there. As soon as you get up there, you're immediately faced with questions, and you spend most of your time responding to the questions because the justices know the arguments, have read the briefs, and what they're really trying to find out is the implications of your position. So they're pushing you on all of this, and you've got to be prepared for that.
Whether they can tear down a Motel 6 to put up a Ritz-Carlton?
That's exactly right. And what I saw that is, one of the things with the Kelo argument that you mentioned, it's when my opponent, when Justice O'Connor asked that question, and she said, under your theory,
he knew he was going to get it, because he probably prepared just like you did.
Yeah, exactly. Could you take a Motel 6 and give it to Ritz-Carlton? And he said, yes, Your Honor, that would be okay. I saw the look on Justice O'Connor's face when he admitted that, which was the fundamental point of our argument, and I thought, I think we're making some progress with Justice O'Connor right now with it, and so
but that's not the justice you needed. You needed Kennedy, right?
Well, that's right. We had to get 5 for it. But Justice O'Connor had written a broad opinion about eminent domain about 20 years before that. So we were wondering about where she would be on this, and of course she voted with the property owners and wrote this magnificent dissent, one of her last opinions she ever wrote on the court, that really set the stage for this backlash against the decision that we saw that happened in its wake.
Well, Scott, I appreciate your time, and I actually got extra time here because I screwed up at the beginning, and I apologize to you, and Nico. I apologize to our listeners. Thank you so much.
Thank you.
That was Institute for Justice President and General Counsel Scott Bullock. To learn more about Scott and the Institute's work, visit their website at ij.org. This podcast is hosted, produced, and recorded by me, Nico Perino, and edited by Aaron Reese. To learn more about So to Speak, you can follow us on Twitter at twitter.com/freespeechtalk, or like us on Facebook at facebook.com/so-to-speak-podcast. You can also email us feedback at so-to-speak@thefire.org, or call in a question for a future show at 215-315-0100. Again, that is 215-315-0100. If you enjoyed this episode, please consider leaving us a review on iTunes. Reviews, as I mention every week, help us attract new listeners to this show. And until next time, everyone, please have a happy new year, and thank you again for listening.